versus the City of Greenville et al., case number S11A1645.
James Radford for appellant, Theodore Meeker and Alan Miller for appellee.
Mr. Radford.
Good morning, Your Honors. My name is James Radford. Thank you for hearing our appeal this morning. I represent the appellants in this case, plaintiffs in the court below. That's Darryl Williams, the former chief of police of the City of Greenville, Georgia, and Johnnie Mae Owens, the former city clerk of the City of Greenville, Georgia. The focal point of this case today is the action of the defendant, Mr. James Bray, who is the mayor of the City of Greenville. In January 2008, Mr. Bray unilaterally, without a vote and against the express wishes of the City Council, terminated the city clerk and the chief of police and appointed his own choice for replacements as the new chief of police and the city clerk of the City of Greenville. This action violated the express provisions of the city's charter and its ordinances. The city's charter, which is much like the Constitution of the city, requires that the appointment of officers be accomplished by a 2/3 vote of the City Council. In other words, the separation of powers that is contained in Greenville's charter gives the power to the City Council to make these important decisions with regard to city officers. The charter does not give that discretion solely to the executive branch, i.e. the mayor, to make those decisions. This is an instance in which the mayor accomplished by unilateral, extra constitutional, but extra charter action, what he was not able to accomplish through the lawful political process demanded by the city's charter. The mayor admitted in his deposition that he terminated the plaintiffs. He admitted that at the time he terminated them, there was a full quorum of the City Council he could have brought that decision to, but he did not because the City Council did not want to terminate the plaintiffs. The mayor admitted in his deposition that he unilaterally appointed a new city clerk and a new chief of police during a time when there was a full quorum of the City Council who could have voted on the matter. Again, he did that because he found, I suppose, the political process too difficult. He could not get his agenda passed through lawful means, and so he usurped the balance of power that is mandated in the city charter of Greenville and accomplished through unilateral action what he was not able to accomplish through the lawful political processes. There is a specific statute that allows my clients a cause of action against the mayor. That is Georgia Code 3633-4. That statute says, members of the council and other officers of a municipal corporation shall be personally liable to one who sustains special damages as the result of any official act of such officers if done oppressively, maliciously, corruptly, or without authority of law. The evidence in this case was truly undisputed that the city charter did not allow the mayor to unilaterally make this decision. That is a decision that was delegated to the legislative branch of the city, the council in this case, and the mayor violated the clear word and of the charter and the structure of separation of powers in the city government established by that charter and the lawful ordinances.
Are you relying solely on the without authority of law part of that statute?
Well, I would also contend that this was an act done corruptly and maliciously.
Is that alleged in your complaint?
Yes, Your Honor.
The malicious and corrupt part of it?
Yes, Your Honor. Corruptly is a term that really hasn't been defined in the case law, so we don't really have a debate today about what that means. But maliciously is defined in this statute as not the sort of punitive damages malice, i.e., intentional desire to do evil, to harm someone, but a specific intention to carry out the action knowing that it will cause harm in the end. And the harm here being the loss of employment. Fortunately, this case does not require the court to answer any thorny constitutional questions regarding due process or the property right to continued employment. Now, that's not the issue in the case today. The issue in this case is very simply, what does the City of Greenville's charter mean? What powers does it allocate to the executive branch, and what powers does it allocate to the legislative branch, the council of the city government? And did the mayor act without authority of law in this instance?
That's not the question for us, though, is it?
Well, that's one of the questions. The district court, the trial court's order is sort of a mishmash of issues, and one of the findings that the trial court made was that was a factual finding that what the mayor did in this instance was not terminate the plaintiffs, that, however, the plaintiffs had annual terms of office, and those terms simply were not, there was no motion to renew their annual appointments. That is inconsistent with the reading of the city charter. It is a fact that in this case, the City of Greenville's charter does not set a hard cap on the term of the chief of police and the clerk, the city clerk.
But as I understand, all the trial court's determinations led up to ultimate conclusions about immunity and jurisdiction.
Yes, Your Honor, and I'll go ahead and get into those issues.
So that's really what's before us, those immunity issues and jurisdiction. If we rule in your favor, the most we would say is there is no immunity and there is subject matter jurisdiction. All these other issues would be resolved at the trial court level, wouldn't they?
Yes, Your Honor, we think that there are issues that a jury would need to determine. However, the district court did determine, as a matter of fact, that Mr. Bray did not terminate my clients, that he simply allowed their annual appointments to expire. It's important to note that that is an issue before the court today, and as outlined in our brief, the mayor testified in his deposition that, yes, he did terminate them, that he did not simply allow an annual term to expire. So that was an erroneous finding of fact that the court made that we would also ask this court to revisit. I'll move into the jurisdictional issues, which I think are really wholly without merit. The first issue, and I don't know...
Could you back up?
Yes.
Had their term expired before he terminated them?
No, Your Honor.
Okay, so he physically, he says, or actually terminated them before the term expired?
Yes, Your Honor. I asked him this in this deposition. I said, if it's your position in this case that they had annual terms that simply would have naturally expired, why did you terminate them? And he said, I just felt like I needed to terminate them. I wanted them gone. And there was no evidence as to when, if there were annual terms, when that annual term would have begun or ended in this case. There simply was no evidence to that effect. And this case is distinct from a case cited in the briefs, City of Buchanan versus Pope. In that case, the charter of the city set a specific 12-month cap on the time that the chief of police could serve, and there was evidence in the case as to when that term ended and, when that term began and when it ended. In this case, there is no hard cap, and there's no evidence as to, even if there was an annual term, when it begun or when it ended. And the mayor's act of telling them you're fired sort of belies any notion that their terms naturally would have expired. The trial court made the finding that it lacked subject matter jurisdiction over this matter because it was a political question. I don't want to spend a lot of time on this issue because it is plainly incorrect based on governing case law. I would point the court to the case of Thompson versus Talmadge, where the Supreme Court had to decide whether Governor Talmadge had rightfully been appointed by the legislature in the absence of a majority popular vote, which was the constitutional provisions at the time. And the court in that case said, just because an issue is politically contentious or because it requires the court to make decisions that would interrupt the political decisions of other branches of government, that does not make it a political question. And the trial court in this case said that this was a political question because it was a, quote, political situation. Those are two very different things. Clearly, there is a charter of the city that governs the separation of powers within the city. And there are statutes like Georgia Code 36-33-4, which hold municipal officers liable when they take action that is inconsistent with the local laws that govern their operations.
Well, if you're going to go down that without authority of law path, you have to explain why that's consistent with sovereign immunity in the Constitution.
Yes, Your Honor. And
It requires malice.
Yes, Your Honor. I'll move to that question right away. There are two types of immunities in this question. One is the official immunity that Mr. Bray personally would enjoy, and then the other is the immunity as to the entity, the city, that the city would enjoy by statute. With regard to Mayor Bray, I would point the court to the city of the case of Ward versus Statesboro, in which the Court of Appeals held that Code Section 36-33-4 is a specific waiver of official immunity as to an individual official if they indeed act without authority of law. And if they intentionally act without authority of law, that establishes malice. In this case, we think it's pretty clear that the mayor knew exactly what he was doing. He met with the city council and said, I want to fire these people, and the city council said, no, we won't stand for that. And then the next day, he gave them letters of termination. I think the malice element is certainly met in order to waive Mr. Bray's individual immunity. As to the city, the statute with regard to municipal liability states that immunity is waived if the municipality has an insurance policy that covers liability for the specific tort in question, and then it has waived immunity to the extent of that coverage. The evidence in this case showed, and this is outlined in our brief, that the city at the time had purchased a public official's errors and omissions policy that covered the city for up to $1 million for losses arising from each wrongful act. Wrongful act in that policy included employment practices, and employment practices were defined as an actual or alleged improper employment-related practice, including wrongful dismissal, discharge, or termination of employment in violation of federal, state, or local laws concerning employment. That is a perfect fit with the allegations of the complaint and the evidence in the complaint. The city had purchased liability insurance that specifically covered the cause of action contained in the complaint. Under the plain meaning of the statute, that constitutes a waiver of the city's sovereign immunity to the extent of such coverage. It's really clear from the reading of the insurance policy, which is contained in the record. Another quasi-jurisdictional question that the trial court answered was that we had failed to provide improper anti-litem notice. With regard to that point, it has to first be clarified that the anti-litem statute, by its express language, only requires notice as to the claims against the city as an entity. It does not apply to claims against Mr. Bray individually. That's outlined in our brief. I want to cite an additional case that is consistent with that point, the case of Conley versus Dawson. That's 257 Georgia Appeal 665. In that case, a woman sued a police officer alleging that he had acted fraudulently in covering up evidence that was part of an investigation. It was a city police officer, and he was sued in his official and his personal capacity. However, the plaintiff did not serve the city with anti-litem notice of the claims. In that case, the court said that the claims against the officer in his official capacity could not proceed because that was, in fact, a claim against the city. However, the claims against the officer in his personal capacity could proceed. So anti-litem notice would not be required. Even if you all were to determine that we did not notify the city timely, that does not preclude our claims against the mayor in his individual capacity here. Sorry.
What do you say as to the claims against the city?
Yes, Your Honor. As to the claims against the city, the court just got this wrong. We notified the city by letter in February of 2008, which occurred about a month after the improper employment acts. That letter said the letter was sent to the mayor, and the letter said that our clients' terminations were quote unquote unlawful because their terminations had quote not been approved by the city council.
That included a claim, though.
Yes, Your Honor. And the letter referred to those disputes as claims, legal claims that we were going to bring against the city if they did not resolve them in our favor. I would remind the court, as we reminded the trial court, that the anti-litem notice statute is to be strictly construed against the municipality because it is in derogation of the common law. The Court of Appeals has said that notice to the city must simply give the municipality notice of the grievance against it. It is necessary only that the municipality shall be put on notice as to the general character of the complaint, that is, in a general way as to the time, place, and extent of the injury. And the purpose is so that the city can investigate the allegations against it and present those claims to any insurance adjuster for adjustment. Mr. Brake and the city could not honestly and in good faith claim that when they got a letter from a law firm in February 2008 saying that we had legal claims against them for unlawfully terminating our clients and not giving the city council the opportunity to vote, the city cannot argue that they did not have fair notice of our claims, which are the exact same claims that we are here on today. It wasn't a letter that went into excruciating detail about all the evidence that we plan to present or the legal theories and specificity that we plan to proceed upon, but the statute simply does not require that level of specificity. It only requires that the city be notified as in a general way about the claims so that they can fairly investigate and adjust those claims if necessary. If the court would permit me, I would like to reserve the rest of my time. Just
on the sovereign immunity point, you say the insurance covered wrongful termination.
Yes.
Did it cover intentional torts?
Well, anytime there's a wrongful termination claim, there are two levels of intent. There's obviously he intended to fire them, and we think that satisfies the type of malice that is necessary in order to meet the statute. You
can reserve the rest of your time.
Thank you, Your Honor.
Thank you, counsel.
Thank you.
Mr. Meeker?
I'm Mr. Miller.
You're
Thank
Mr.
you, Your
Miller.
Honor. Good morning. I am Alan Miller, and I, along with Ted Meeker, the city attorney for Greenville, are representing the appellees, the Mayor Bray and the City of Greenville. We, of course, would urge this court to affirm the trial court's decision granting our motion for summary judgment in full. That motion was based on 4 grounds, basically, and I plan to argue 2 of those grounds, which are the political question and the sovereign immunity ground, while Mr. Meeker, the city attorney, will discuss the other 2 grounds, which were the failure to timely provide proper ante-litem notice, as well as the lack of a continuing property right on the employment ground, which will be covered by Mr. Meeker. Now, I need to respond to some of the facts that were discussed by Mr. Radford, because I do think those facts are key to this court's decision on especially the political question ground as well as the sovereign immunity ground. It was, and to understand just basically the political climate that was going on in Greenville, Georgia, back in the fall of 2007. In the fall of 2007, that's when Mayor Bray decided to run for mayor of the city. It was appellant Johnnie Owens, who was the sitting city clerk at that time, that actually decided against him on his residency issue. It was that decision made by appellant Johnnie Owens that Mayor Bray had to appeal to the Superior Court in order to have the Superior Court reverse that decision in order for him to run for mayor at the time. In addition, it should be emphasized here that Mayor Bray won that election in November of 2007, fair and square. He won mayor. Now, the then sitting city council at that point then appealed the Superior Court's decision to this court. And this court ruled in, I believe, November of 2008 that all issues were moot, and as a result of Mayor Bray's election, there was no decision to be made here. Now, Mayor Bray did take office in January of 2008, and he attempted to discuss with the then sitting council his decision, or his, request to terminate both the appellants, appellant Johnnie Owens, the city clerk, and appellant Darryl Williams, the chief of police. This is the same city council that had just appealed the decision of the Superior Court to this court. Now, the city council put him off at that point in time. They did not say no, as Mr. Radford said. The evidence would show that they did say, we want to take it slowly. We're not sure we want to do this. Let's just take it slowly. Now, Mayor Bray did initiate those terminations of both the appellants anyway, and in his mind, he did that for cause. Under the ordinances that were in place at the time, Section 3-302, the duties of the mayor shall have the following duties: to dismiss, suspend, or discipline officers and employees for negligence or inefficiency in performing the duties of the position held, and also, under H, political activity in violation of the municipal regulations. Certainly, Mayor Bray at that point in time felt that both appellant Johnnie Owens as well as appellant, the former police chief, Darryl Williams, had violated that ordinance.
Based on what activity?
Based on the activity for appellant Johnnie Owens, the city clerk, she had actually been brought up on election violations by the election board. She had also ruled against him on his petition, of course, and she had also refused to certify his election even after he won the election, the general election in November of '07. In addition, it was obvious to Mayor Bray that she openly supported the former mayor, which was Mayor Byrd, in her campaign against Mayor Bray, who was his opponent in the November '07 election.
And how much of this was raised at the trial court that Owens was dismissed for cause for the reasons you just listed?
In our motion, it was raised as a basis for the grant of the motion for summary judgment, Your Honor. This was a motion for summary judgment, which we argued, and it is certainly in evidence that she was brought up on election charges. She was found in violation of those charges. I think she pled it out by the election board. In addition,
She didn't dispute, nobody disputed any of that, and no disputed issues of fact or intent about any of the things you just told us?
well,
It appropriate for resolution on summary judgment?
no, they did
It's
not.
all just, they admit they did it all for political
Well,
reasons.
it was pled out by her and was worked out in a plea bargain, I believe, Your Honor. But I do think that in Mayor Bray's mind, that certainly was one of the basis why he felt he had a for-cause determination at the point in time in early January that he decided to terminate both the appellant.
How do you read that ordinance that you just told us that said he can terminate for cause with the ordinance that was passed in October that said he can initiate all hiring, firing, raises, and promotions can be initiated but have to be affirmed?
I think it should be read in conjunction with that duties of the mayor, because that very ordinance, which was what I was just getting to, was what I think he initiated the firing of. And then when he, in January of '08, when he initiated the firing of both appellant Williams and Owens, the city council then in the very next regular session on January 8th of '08, several city council members decided not to show up at that meeting. And at that very meeting, they could have very well affirmed or reinstated both the chief, Williams, as well as the city clerk. But the city council decided not to show up at that meeting. At the next meeting, January 15th of 2008.
Was it on the agenda at that meeting?
I don't know that it was on the agenda, Your Honor, but I think it could have been. It very well could have been.
Whose responsibility would it have been to put it on the agenda?
Well, under the resolution simply stated that the decisions of the mayor in firing or initiating the firing of any officers must be affirmed in regular session by the city council majority vote.
Well, I guess I'm trying to figure out what weight to put on the fact that the council wasn't there. That's only important if that was going to be brought up at the meeting. How do we know? Do we know from the record if it was going to be brought up at the meeting?
We do not know from the record, I don't believe, Your Honor. I'd have to check that. I do not know for a fact that it was on the agenda for the January 8th meeting. I do know for a fact that on the January 15th meeting, when certainly any business of that nature could have been conducted, two of the city council then resigned, forcing the city into receivership. And therefore, in addition, at that point in time, the resolution that Justice Namus mentioned in October of 2007 that actually gave the mayor the power to initiate the firing of both appellants could not be discussed at all because two of the council members were resigned. There was no majority vote.
Did the receiver ever approve it on behalf of the city?
This receiver did not ever approve it, but this receiver did appoint both the new chief as well as the new clerk, and during the interim period of time in order to conduct city business at that point.
When you say initiated, did he tell them they were going to have to leave, or did he take them out of their office and put new people in the office? I have trouble understanding the word initiated to mean you basically do it complete in all practical effect as if it's done.
Well, I had the same problem. I mean, but the initiation of a firing, which is what the resolution was worded, I mean, that was the wording used by the city council in 07 before Mayor Bray was ever elected.
And
so that initiation of firing, I don't know how else Mayor Bray could have done it, but he did hand at least Johnnie Owens a letter saying you were terminated. He did try to hand a letter to Chief Williams saying, I'm going to terminate you, but...
And then he appointed new people and had them go into their offices and start acting on behalf of the city?
I don't think that it was that quick. And in addition, as to Chief Williams, he actually delayed his termination till like the middle of February.
Well, I mean, so you read initiate with the city council to affirm to mean that the mayor can basically tell him you're gone, and that's the end of it if the city council never takes action.
No, I think the city council would then make the determination whether or not under the resolution they would affirm.
And they never did take action.
No, they didn't, because they resigned instead.
And you say that, can I just follow? You say that's okay. So if if the president nominates someone to be, say, a judge, and the U.S. Senate never has a quorum to act on it, even though the president really wants them to, at some point that person can become a judge because the president initiated it, and even though the U.S. Senate's never confirmed that person, that's good enough?
Well, I think the city council could have reaffirmed or reinstated either appellant when they were reelected in the summer of 08 or the summer of 07. So I don't think that is nearly the case. It was just the case in this case where he did terminate him, but then the city council decided to resign, so there was no majority vote to either take up their appeals at that point in time, or to reinstate them or affirm his decisions. And for that reason, we believe that the political question certainly is here, and we would cite to the case, this court's case in Beal versus Beal, which simply states that measures exclusively of an executive character are not examinable by courts. In such a case, the remedy for any real or supposed abuse is solely by appeal to the people at the elections.
So all this discussion we've been having today about what the charter means and wrongful termination law and anti-litem law, that's all just political stuff. It has nothing to do with law.
No, I think that it definitely is one of the grounds for the court's decision, Your Honor. But I believe also as well there is a political question going on here in Greenville in 2007, 2008, when the newly elected mayor is having to deal with a city council like this and trying to put people that he wants to work with in the positions with him in his cabinet per se, and he is not allowed to do so because the city council resigns thereafter. Now, as far as the sovereign immunity...
Wouldn't Marbury versus Madison have come out a different way? Mr. Marbury was involved in a very heated debate between the Federalists and the Anti-Federalists, and the U.S. Supreme Court said that's what courts do. They decide legal questions, even if behind them there are very serious political arguments. You seriously think that this is a political question immune from judicial review?
I do think that that's one of the basis for the trial court's decision.
I do think that you drafted an order that the trial court signed saying it's a political question. I'm asking you, are you standing here and saying this is a political question immune from this court's review? I
certainly think that's one of the weaker grounds, Your Honor. I do think the sovereign immunity ground is much stronger. The sovereign immunity ground where the has not been waived here by the insurance policy. The insurance policy does state that only requires or does require unintentional, unexpected acts. This certainly was an intentional act. There's also certainly no willful discharge here because of the fact that the charter does state quite clearly, and it controls here, that the election of all officers is annually, that the intention of the act is to elect all officers annually. Now, I'm going to let my brethren here, Mr. Meeker, discuss those two issues, if you would.
Thank you, counsel.
May it please the court, my name is Ted Meeker. I'm here to present the last two issues in terms of the anti-litem notice and the non-reappointment. Justice Namias, you asked a question a little while ago about the ordinance that was adopted in 2007. Of course, one of the tenets of local government law is that whatever ordinance council adopts, it has to be consistent with the charter of the city. The charter provisions, hopefully that'll clear up, there are two relevant sections. One is section 8, which references how the votes or when the mayor can vote, and it references the annual appointment of officers. Over in section 12, it has the same language, and in fact goes further to state that it's the intention of this act to elect all officers annually. Further up in section 12, it references when those elections are supposed to take place. They're subsequent to the election or the council elections and the new council members and mayor taking office. The arguments this morning have centered a lot on an act of termination. In fact, the real issue before the court is the actual annual appointments and whether they occurred. The mayor perhaps did not want to renew the chief of police or the city clerk. Under the charter, the council could have clearly acted and installed them at their meeting in January. They did not do that. Rather, some resigned, therefore removing a quorum and the receivership that's noted in the record. The facts of this case, I believe, fit squarely under the City of Buchanan versus Pope case. We've cited that in the materials and due to a little bit of limitation on time, I'm not going to get into that case in any great length. But under that case, it's clear that just because a chief had been around for a long time or there had been a contract, those actions cannot exceed the power given to the city council under the charter to go beyond the term of office or to go beyond the annual appointment. The distinction between a termination and a non-renewal of a position is not something I'm just making up this morning. That is a distinction that's recognized under Georgia law. It was cited in the Buchanan case and was also cited in Hudgens versus City of Ashburn, which is an 11th Circuit case in 1989. Mr. Radford said both this morning and on page 19 of his brief that they are not claiming a property right to continued employment. Under the case of Wilson versus City of Sardis, 264 Georgia Appeals 178, 2003, the court in that case clearly held that if there's no property right or claim of entitlement to continued employment, there can be no claim for wrongful termination. This is not really a powers question that's before this court this morning. The powers are very clear under the charter in terms of the annual appointments that they could have made. And as I said a minute ago, the council could, in fact, have appointed them. But based on the language of the charter itself, it's also clear that whoever was in the position of clerk or chief of police did not have a right or a property right to continued employment beyond the annual appointments referenced in the charter itself.
He says not property right, but he has a cause of action under 3633-4.
Your Honor, I believe, again, it goes back to the question of whether they have an expected right to continued employment with the city or not. In other words, if they don't have that right, then I don't know any claim for wrongful termination or any other employment-related claim, absent, of course, of civil rights or some other type of claim that could be brought against the city under the scenario outlaid or laid forth in the charter.
Let me make sure I understand your argument. Are you arguing that the original terms had expired and they had carried over?
I am arguing that their terms had expired.
Okay.
As of, I believe it would have been December 31st of 2007, or at least until that first meeting.
The terms expired prior to being terminated?
Yes.
Okay. And so at that point, they were carrying over?
Correct.
And they didn't pick up a new term at that point. In your view, they were terminable at will?
Correct. Okay. With respect to the anti-litem notice...
let me just follow up on it. And so even if terminable, you say terminable at will, even though there was an ordinance saying how terminations could be done?
Yes, Your Honor, because as I noted before, the fact that the city might have adopted an ordinance in 2007, that ordinance was inconsistent with the city charter.
Well, how's it the charter just says how to elect people. It doesn't say what to do with the people if you haven't elected new people. And we have situations all the time where people carry over for one reason or another. Normally, and there's actually a statute that says people who carry over continue until a successor is appointed.
Right, but unless that appointment takes place, Your Honor, then it doesn't go beyond that term of office. In other words, let
Are they in a different status if they're holding over than if they were holding on to an appointment for a year?
Excuse me, Your Honor?
Are they in a different legal status holding over than they would have been if they were during the regular calendar year?
That would be our position, but to be honest with you, I don't think under the terms of the charter that, other than that annual appointment, they have any right to, or property right to continued employment with the city. I'll try to be brief on the annual item notice. Before you is the letter of February the 18th. The record is going to show that Ms. Owens was terminated effective January 4th. Of course, the 6-month time period in which she could have set forth her annual item notice would have expired in July of that year. Chief Williams, his effective date of termination was February the 16th of 08, so therefore he had until August of that year to submit. With respect to Ms. Owens, the only relevant annual item notice is the one that I've put before the court this morning. It is contained in the record. You will note that it referenced clearly their request for an appeal. It also set forth a claim for, or notified the city of a potential claim for defamation. It did not set forth the claims that could be raised against the city as a result of the city's actions. I would submit that this case is very much like the Davis versus City of Forsyth case that we cited in our brief, and also Harris-Jackson versus City of Cochran, found at 287 Georgia Appeals 722. Both of those cases had instances where there were actual claims raised against the city. The claims raised in both instances had to do with property damage. The plaintiffs in both cases later came back and not only sought claims for property damages, but also for personal injuries. In both of those cases, the court said that the annual item notices were not sufficient and struck the claims. In this instance, I don't believe that the February 14th letter clearly put the city on notice of what potential claims might be raised against the city. Thank you very much.
Thank you, counsel. Mr. Radford?
Your Honor, again, this is not a case about a due process property right to continued employment. The right in question here is a legal right that these individuals had to not be subject to actions that violated the charter of the City of Greenville. That's the only question before this court. In the case of Buchanan versus Pope that my brethren cite, that was a question of whether the chief of police had a due process property interest in his continued employment due to a personnel manual that he drafted that was antithetical to the city's charter. And in that case, the mayor of the city and the city council lawfully voted to terminate the employment of the chief of police. His termination was carried out in accordance with the provisions of the city charter. The city was insisting that the charter held sway, and the chief of police was insisting that his personnel manual held sway. So you have exactly the opposite situation of what you have here, where my clients are insisting that their legal right under the city charter was violated and that the mayor had to.
What would your remedy be?
Well, we think we have a damages remedy against Mr. Bray individually under the 3633-4, specifically allows us to obtain damages, and we're also entitled to a writ of mandamus ordering that our clients be reinstalled until such point as the city council could vote through the normal 2/3 majority reappointment process that the city charter holds.
Has the city council, the new members, not done that to appoint the new people?
No, sir, not until the subsequent year. Basically, the receiver appointed the two individuals who Mr. Bray had unilaterally put into that position so that there could be continuity with the city government. And then in the following year, there was a vote by the new city council to appoint Mr. Bray's replacements. But this is 3633-4 is essentially a tort action. So the question ultimately before the jury will be, but for Mr. Bray's wrongful actions here, would the city council member, what would have happened? What we believe would have happened is and this is supported by the letters we have from the members of the city council, is at the first meeting of the council during which this annual appointment process could take place, Mr. Bray would have filed a motion to say, I wish to appoint my new selection for a city clerk and my new selection for a chief of police, and as a result terminate my clients. The city council would have rebuffed him and they would have not have gone along with that. then a city council member friendly to my clients would have made a motion to appoint my clients, and the city council would have voted in favor of that by a 2/3 majority.
What do you say to the notion that once the original term had expired without any further action, official action, that she became an employee at will?
That assertion is simply not supported in the record. There's not a shred of evidence in this case that my clients' annual appointments had expired. There is no evidence as to when their appointments began, and there's no evidence that those terms had expired. And if they had expired, then there would have been no reason for the mayor to hand them separation notices and say, you are hereby terminated.
So your response is everybody was operating as if she was under the term?
Yes,
and
Your Honor.
And had to be terminated pursuant to those provisions?
Yes, Your Honor. In the past, the city council had reappointed these individuals through unanimous consent, and that was what was continuing to go on. I want to respond briefly to Mr. Miller's argument that the ordinance saying that initiate their termination means to actually terminate them. I mean, that is just so obviously not the intention of that statute. That is, the mayor could make a motion, I wish to terminate these folks, and then the city council would have a chance to vote on it. It does not mean that the mayor hands them a termination notice and installs their replacements. That's not initiating. Thank you, Your Honor.
Thank you, counsel. This court will stand recessed until 2 p.m.